Jerry, I'd like to take a couple different fact scenarios, three different types of clients who would come into your office with problems that have to be resolved in the federal courts. The first one dealing with someone who's under investigation for white-collar offenses. The second one dealing with someone who was arrested for a crime of violence, let's say bank robbery, arrested either by the local police or by the FBI. And the third one, a drug-type case, someone charged with either drug distribution, possession with a firearm, something that would be a federal type offense. Let's start off with the person who's under federal investigation for a white-collar offense. And in our scenario, gentleman coming into your office says, the FBI wants to talk to me. I think it has to do with mail fraud and wire fraud related to a business that I owned. Mm-hmm. I'm also getting letters from the IRS. They want to talk to me about why I didn't file some returns going back 4 or 5 years ago. You have people like this come into your office, I take it, on a fairly regular basis.
Yes.
How do you handle things like this?
Well, the first thing I tell somebody when they come into my office in that situation is that they really need to make one decision, and that is who's going to represent them. So the first conversation I have with a client when he comes in the door, and it's a white-collar situation, you find a little bit about his background. You'll generally find that they're generally a well-educated individual, participate in one or more businesses. Sometimes they're professionals. Sometimes they're doctors, they're lawyers, accountants. And I usually tell them very clearly that it's just like being sick, that the first thing you need to do is find a doctor that you have complete, full faith, trust in. Mm-hmm. And you're going to put your trust in that doctor, and you're going to listen to what the doctor says. It's the same thing with an attorney. They have to choose someone that they feel is going to give them the best advice possible and listen to that individual. And then I talk to them whether or not they feel that I could be that individual. I often recommend that they go out and talk to other attorneys and find the person that they feel has a connection with them. Once that happens, if they say to me, no, we would really like you to represent me or us, it's generally a multiple situation. It's generally a family, or it's a brother and a sister, or it's a president and a vice president, or there's generally several individuals that are involved. So the first thing we have to talk about are conflicts. Mm-hmm. Often you'll have, if it's a company, you'll have two partners walk into your office, and they'll want to have this conversation with you. So after you talk to them and identify for them the issues about choosing a lawyer, you then have to talk to them about the potential conflicts. And you have to explain to them the essence of the attorney-client privilege, and that it truly is an attorney-client privilege between the attorney and that particular client. And there's no partner's privilege, there's no father-son privilege, Even a spousal privilege may not prevail in a situation like that if it's a business conversation and not.
Assuming that one of them, though, is going to have the wherewithal to retain you to represent them, now your immediate problem is that the FBI wants to come and interview this person in a day or two.
Right.
Generally, how do you handle this type of situation?
Well, I generally ask them if the FBI has been to their office, and I try to identify who the FBI agent is. Mm-hmm. And through the FBI agent, I'll identify who the U.S. attorney is. So the FBI very rarely runs off conducting investigations like this on their own. They're generally on the leash of an assistant United States attorney someplace.
Question about that. On these cases, how far back does it go to Washington in terms of where they get direction on when they're going to target an individual? Do they have autonomy locally, or do they have to get clearance from Washington to do these things?
The United States Attorney's Office has a great deal of autonomy locally. The FBI, less. Every report that the FBI writes, they write what's commonly known as a 302. All of those reports go up the chain and eventually winds up at a desk in Washington that handles white-collar crimes for this particular area, say for the Northeast area.
Okay.
But they don't really become too involved in the decision-making unless it's a real high-profile case. If it involved an elected official, for example, if it involved a governor or a senator, then you might have the FBI more involved. But, the United States Attorney's Office and the Department of Justice really has the last word.
Okay.
So what I try to do, because I tell the client, sometimes they'll come in and they'll say, well, the FBI told me that if I come in and talk to him that, it'll go a lot easier on me, mm-hmm. Or maybe they won't bring any charges. And I really try to let the client understand that the FBI has absolutely no authority to make any of those representations.
Okay.
So I try to get to a U.S. attorney. So if the client comes in and tells me that they want to talk to him, the first thing I do is pick up the telephone and identify the assistant U.S. attorney who's handling the case.
All right.
Then when I do, I tell them that I'm representing this individual, and they're magic words, basically. When I say to the U.S. attorney, I have been retained to represent Mr. Jones, I am now his attorney, the United States attorney knows that that means no more conversations with the client, no more knocking at the client's door, no more seeking information from the client, no more contact of any kind with the client, either by the United States Attorney's Office or the FBI. So then the United States Attorney and I, we start, a conversation, and basically it starts, so why do you want to talk to him? What's going on? Tell me what you can tell me.
Supposing that your client has already, though, let's say that there was the FBI showed up at his house one morning at 8 o'clock in the morning, knocked on his door, and he's kind of groggy, and they start asking him questions, and he's foolish enough to talk to them. Right. How do you undo something like that?
You can't undo it. You really can't. All you can really try to do is determine how much damage he's done and try to minimize the damage. So I'll ask him to be very specific with me, almost to a degree that can be annoying. I'll say, tell me the questions that he asked. Tell me every question that he asked and tell me every answer that you gave him.
Right.
And I will laboriously go through that. And then after he tells me what happened, I'll call the United States Attorney and tell the United States Attorney, have the same conversation that I would have had with him had the client not spoken to the FBI.
Right.
And then I'll say, well, I understand that Mr. So-and-so made some statements to the FBI. What did he say? And I'll try to get the U.S. Attorney to tell me what the FBI's take on what he said was.
But typically the FBI is not recording these, they're writing down the answers.
Ever since Hoover, it has been the policy of the FBI, not to record interviews, no matter how important they are. The FBI does not record interviews. And Hoover's reason was that the FBI doesn't need to record statements. We are the FBI, and that if an FBI agent takes the witness stand and takes the oath, that's good enough.
Okay.
So what I tell my clients often, whether the FBI agent has good motive, bad motive, or otherwise, the real difficulty happens is when he sits down and speaks to an FBI agent, that the reality is not necessarily what he said, but what the FBI agent wrote in the 302.
Well, there's another side of this coin, though, it seems to me, because my experience has been that when the FBI shows up to talk to you, they're really not going to get any new information. In other words, they're so well prepared, they know ahead of time what they're looking for, what the answer should be. And I think where you get into trouble is where you give the FBI false information during your interview. Do you agree with that? I mean, in terms of the level of their preparation when they go for the interview in the first place?
It's generally true. They're not really looking for information. What they're looking for is a confession. Okay, they're looking for admissions. They're looking for the client or for what they target to make statements that's going to end the discussion and going to close down the prosecution. Now they've got him. And that's what you really have to be careful, because sometimes a client will talk to the FBI and they'll say certain things, and then you look at the 302, which is the designation for the FBI report, and you read what the FBI report says that the client said, and you talk to the client, and the client says, well, I didn't say that. Well, that's not what I meant. So the reality breaks down between what the client says and what the FBI thinks he said, or whatever the FBI wrote.
How often do you get into these situations, though, where the U.S. Attorney will then have additional evidence in the sense of somebody giving a false statement to the FBI during the course of an interview?
Well, if I talk to clients and I have any input at all with regard to them giving an interview to the FBI, the first topic of conversation is the truth. And that is never, ever go into an interview with a federal agent or an assistant U.S. attorney thinking that you can parse the truth, thinking that you can either outright lie to them or even hold back information, right? Color the truth. It just can't be. If you're going to go in and talk to them, you have to give it all to them.
What's the consequences, though, if you do lie to the FBI?
Well, first, if you lie to the FBI, there's a rule of evidence that permits, at the time of trial, suppose you lie to them and you think you try to give them some excuse, there's something that's called a false exculpatory. And if you give something to the FBI and it's not the truth, and the FBI can prove that you lied to them, if you go ahead and assert your defenses and assert your innocence at the time of the prosecution of the trial, they can actually put the FBI agent on, and he'll testify in front of the jury that when you were interviewed by the FBI, you lied to the FBI.